Welcome to the McNees Litigation Podcast Series. In this video podcast, Attorney James Franklin discusses the importance of reading user agreements and terms and conditions. Mr. Franklin is a member of the litigation, insurance law, and personal injury practice groups at McNees.
Read the fine print. That's a phrase we've all probably heard. It's advice you may have given or even received. And we know what the fine print is. It's that small language on the back of a contract or a ticket or the end of the instruction manual. And many people don't read those terms and conditions. Yet, even in today's digital age, reading the fine print remains important. And recent litigation involving a well-known company shows that that adage is still true today. Uber. Most of us are aware of Uber, familiar with it. Many of us use it on a frequent basis. It's that transportation, taxi-like service that you call via an app. So most people sign up for Uber through their smartphone, through the app on the phone. And to do so, you need to create an account, do a couple steps, including agree to Uber's user agreement. That agreement contains terms and conditions, one of which refers to arbitration. Now, arbitration is the process where you basically, instead of going to a jury trial, you go to an arbitration and decide your dispute through an arbitrator. Now, some consumer groups believe that arbitration is inherently a pro-business, company-friendly way of resolving a dispute, that it's to the disadvantage of the average plaintiff or consumer. So in this user agreement, in this terms and conditions, what you're agreeing to, now again, the specific language can vary depending on what state you're in or how it's presented, but generally what you're agreeing to is to pursue your claims, if you have a claim against Uber, through arbitration, and you give up your right to a jury trial, to a trial with a judge. Now, many people agree to this without, again, reading those terms and conditions. So Uber has sought to enforce this arbitration agreement in many courts across the states, even in federal courts. So we've seen a lot of litigation on this issue. Uber has carved out some exceptions for some claims that they will not enforce the agreement, but by and large, they've been very active in defending and enforcing this provision. So what's the question? Well, the question is this clause, is this term and condition open and obvious? Is it conspicuous enough that a user, before they agree to it, that they have a fair and full opportunity to read that term and condition, to see it and understand it? Or is it so buried within other legal language, is it so hard to even access and understand that they don't have a full and fair opportunity to see it? Again, courts can't make you read the term and condition. It's all about the opportunity to do so. Courts have been across the board, though, on how they've come down this issue. Some courts, looking at their specific language at issue, have said, nope, it's open and obvious enough, it's conspicuous enough, it's enforceable. You have to go to arbitration. Other courts have said, nope, it's unenforceable. The most recent case came out of New York. A state court out of Brooklyn said that their specific language they were looking at was unenforceable. It was so buried within other legal language, it wasn't distinctive enough that the plaintiff did not have a full and fair opportunity to read it, see it, and understand it before using Uber. Therefore, it was unenforceable, and the plaintiff in that case, it looks like, will get to present her claim to a jury or to a judge. So what are the takeaways? Well, one, you want to look at your jurisdiction. If you use Uber or really any transportation service, look to see if the courts have decided that issue. This recent case only applies to New York, so you want to look at your specific jurisdiction. The bigger takeaway, though, is read the fine print. That adage remains true today. Why? You don't know what rights you may be giving up. You don't know what terms and conditions you're going to be agreeing to unless you read them. That's the only way to make an informed decision. The litigation and personal injury groups at McNees Wallace Nurick regularly monitor for updates affecting the litigation process. If you'd like more information on this topic, please contact me using the information on the screen. Thank you.